I'm actually going to, that's the local ordinance, I'm actually going to take it out to more of a macro level and kind of explain why we have the wine laws that we do and what the hot litigation topics in wine law has been over the last couple of years. As Paul said, the 18th Amendment was started prohibition in 1919 and was repealed in 1933 by the 21st Amendment. Now, the 21st Amendment did two things. Section 1 repealed prohibition, but Section 2, and you can see the text of it up there, and it's also in your handout. I won't read it to you. But it basically said that you can't move liquor around any state in violation of the laws thereof. And that was later interpreted by the courts to mean that the state, every single individual state, has complete autonomy and control over the laws regarding liquor. And the 21st Amendment then became a very powerful tool for the states. And when prohibition was repealed, the states were all left kind of with, like Paul said, a big hole. What do we do with alcohol? What do we do with intoxicating liquors? So what ended up happening is there was not very much uniformity in how they answered that question. And temperance, there was still a very strong sentiment of temperance throughout the states, so all of them wanted to err on the side of regulating. And what regulating meant just after prohibition was that they would set up these systems of laws that today make very little sense in our more modern alcohol-friendly culture and socioeconomic environment. So the 21st Amendment became so powerful that even when it clashed with other constitutional rights, the courts would still sometimes defer to the 21st Amendment, depending on what level of constitutional analysis they were using. For example, one state in the 1970s passed a law saying that women who were 18 and over could drink 3.2% alcohol, but men couldn't. They had to be 21. Now, that's okay with me, but it was not okay under the Equal Protection Clause. The court said that under an intermediate scrutiny analysis that you had to treat men and women equal. And so when the 21st Amendment there clashed with the Equal Protection, the Equal Protection prevailed. Now, that wasn't the case for all constitutional issues. For example, in the 80s, the federal government passed the see if I remember what it's called, the National Minimum Drinking Age Act. And that basically said, if the federal government's going to give you X amount of federal funding for your highways, as long as your drinking age is 21 and older. Now, if it's not 21 and older, then we're going to withhold 5% of that money from you. So the court then had the power of taxing and spending versus the 21st Amendment and said that the 21st Amendment trumped and that the states were allowed to regulate as they wanted. These cases kind of go, like I said, back and forth based on the level of scrutiny that is applied. But the most recent cases that have come down that have been interesting in the last few years is a case called Granholm v. Held. And that was a clash between the 21st Amendment and the 21st Amendment and the Dormant Commerce Clause. Now, to understand this case and the cases that I've cited in my materials, they're 50-plus pages, and it's a ton of just constitutional analysis, incredibly boring unless you're into that stuff, which I'm not, but I got into it just because I love wine and wine law so much. But to understand that, it goes back really to the power that the states have under the 21st Amendment and what they did right after Prohibition. Part of what they did was they had to develop a system for distribution, and that's what the most recent cases have really been about. How do we get our product from the winery to the consumer? And the reason that became important is it's kind of where business, wine, and law intersect in America. We had these laws after Prohibition where we had a very strong sentiment of temperance, and the wine industry in the United States from the 1930s until the 1970s was considered complete junk. if you wanted to drink wine, if you wanted to drink good wine, you bought French, you bought European. You would turn your nose up to anything that would be, an American wine or a California wine. And I'm sure some of you have seen the movie, but it wasn't until 1976 that California really became recognized as a premier wine-growing region in the United States and in the world. Now, at the same time, things were happening for America socioeconomically, and folks who in the 1950s would have a martini started turning to wine as an option instead. And you have your domestic household product. People are making more money. So again, wine was more accessible and affordable. And I'm sure you all have seen that in your own lives over the last decade or two, to where folks now will go for a glass of wine with dinner, and the health benefits, so on and so forth. So you have a growing amount of Americans that want to drink wine, and you have a wine industry that's finally being recognized. But you have these laws that are still in the books from 1933 to 1940. So that started creating problems. And the wine business reacted. They said, okay, part of the problem, I guess I need to back up just a step. Part of the problem that it created was the way which the states regulate